Is the New York legislature allowed to immediately change the Medicaid reimbursement rates for nursing homes without giving any advance notice? To find out, you have to read Aaron Manor Rehabilitation Nursing Center versus Zucker, but it's 14 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of Aaron Manor Rehabilitation and Nursing Center versus Zucker. The citation for this case is 2024 New York Slip Opinion 02126, published by the New York Court of Appeals on April 23rd of 2024. The issue in this case is whether the Department of Finance can apply newly recalculated rates for services of Medicaid without complying with a 60-day lead time that's set in the statute. To understand and appreciate the context of this case, you have to understand briefly that Medicaid is a joint federal and state program established under the Social Security Act, which pays for medical care for people who are older and indigent, who can't afford it, including nursing home care for older people with low income and limited assets. There's two parts of a Medicaid, and Medicaid pays for not-for-profit and for-profit nursing homes and facilities. And there's two components of the Medicaid payment. One is the operating expenses and one is the capital costs. And the operating expenses are for the services rendered, and the capital costs are supposed to sort of cover depreciation of the facility and the physical infrastructure of the facilities. And basically in 2020, COVID, as we all know, COVID was sweeping the world and began taking over, becoming a big healthcare crisis in a pandemic sort of way. And in March of 2020, much of the country shut down due to the COVID pandemic. But even before March of 2020, there was a skyrocketing Medicaid cost situation in New York, resulting in a $6 billion gap between expenses and income. And in April 3rd of 2020, so this is April, this is right around when the world is going crazy with COVID, the legislature passed the 2020-2021 budget, which included a Medicaid cost reduction order, trying to address this gap in funding. And in that order, the New York legislature, this is the New York legislature acting, they reduced the capital cost component by 5% of all nursing homes and amended Public Health Law 2808 to eliminate the residual equity reimbursement factor, which is the payment given to part of the payment that's calculated in getting Medicaid reimbursement. The legislation indicated that both measures, both the residual equity reimbursement factor being eliminated and the capital cost component being changed, the reduction in the cost component shall take place, this is the quote, shall take place immediately and be deemed to have been in full force and effect on and after April 1st of 2020. So this was passed on April 3rd, and they say this is retroactive to April 1st. It's effective as of April 1st. The legislature also stated that the elimination clause applied to the rate periods as of April 1st of 2020. And this is another quote, notwithstanding any contrary provision of law, rule, or regulation. The Department of Finance, whose job it is to oversee the Medicaid program in New York State, then determined that the law now required adjustment of Medicaid rates and removed the residual equity payments, as they understood the law to require them to do, on or after April 2nd of 2020. The new rates were uploaded to the system, and on August 7th, they sent out a letter to all the facilities explaining the new rates that were as of April 2nd of 2020. Plaintiffs then, plaintiffs are 116 for-profit nursing homes that got together to file this lawsuit, claiming that Department of Finance violated the public health law because they didn't give a 60-day advance notice requirement. They didn't give the 60 days advance notice that's required by the statute. They claim that they violated Public Health Law 2807 by not paying reasonable and adequate rates because they killed off that residual equity payment, and that they violated equal protection because they're treating them differently than their not-for-profit counterparts. They move for summary judgment to dismiss the claims. Supreme Court grants some of them, denies some of them, appeals to the Appellate Division. The Appellate Division grants some and denies some, goes to the Court of Appeals. And here, the Court of Appeals, reviewing all this, answers two questions. First, did the Department of Finance act in violation of the legislature's intent when it announced the recalculated rates in August of 2020 and retroactive to April 2nd? They said no. The legislature clearly intended that this be immediate How do we know that? How does the Court of Appeals know that? They say they made it clear because two things. First of all, they had the notwithstanding language, the notwithstanding clause, which said notwithstanding any other law or rule, this is immediate. That notwithstanding clause means it supersedes any inconsistent provision of state law. Also, they said it should take effect immediately and gave a specific start date. That specific start date takes out any ambiguity or vagueness of the term immediately by saying April 1st of 2020 and with the notwithstanding clause together means that the legislature, which is the strongest, it's not the Department of Finance acting on its own. They're following the legislature's requirement. They said it would be immediately, and that's the law. So the Department of Finance was not wrong to do it that way. And the second question is, did they violate Public Health Law 2807 by not providing reasonable and adequate compensation? And the answer is no. By them, they're allowed, the Court of Appeals says the legislature is allowed to cut the component that talks about the equity reimbursement factor. They're allowed to cut that out, and they're not allowed to now try to make up that loss of income by increasing the other amount for their operating costs component. So that's okay. And with respect to the equal protection argument, they say that's wrong because a not-for-profit and a for-profit are different kinds of organizations. Only for-profit organizations even had that equity reimbursement component. The not-for-profits didn't have it. So they're being treated differently from the beginning. So to treat them differently now is not equal protection violation. They have different underlying economic purposes and incentives. And that's the case of Aaron Manor Rehabilitation and Nursing Center versus Zucker. The legislature is allowed to make those laws immediately effective, and they did so in this case. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.